Good evening, everyone. Good evening, everyone.
Good evening.
Just waiting on everybody to get in. Got to pay close attention to the waiting room. All right, I'll go ahead and call some names here. Let me see. Yassine Amar. Is Yassine on here? Yeah, I see Yassine. All right. Can everyone hear me? Can y'all hear me?
Yes.
Yes.
All right. I had to change over to 5G. Sorry about that. All right. Let me see. All right, I see Yassine Amir. Couture artist. Are you here? Yeah, I see your name. I see you. Zaria Ashley. Zaria Ashley. All right. Nadia Bell.
Here.
All right. Jalen Brumby. I see Jalen Brumby.
Yeah.
Okay. Michaela Cleveland. Michaela Cleveland. All right. Larry Colbert. Larry Colbert. All right. Ayana Collins Roberts.
Here.
All right. Maya Cross.
Here.
All right. Marius Davis.
Marius. Here.
Marius, I'm sorry. Sorry about that. All right. Jada Downs just connected. Janae Harris. I think I see that's you on the iPhone. Janera Harrison. All right. Xavier Hayes. See Janera Harrison now. Hold up. Xavier Hayes. Lashina Hazel. Hazel. All right. Okay. Dea Hilliard. Hilliard, I'm sorry. I see you,
Here.
Dea. Okay, good. Shanique Hines. Shaniqua Hines. She's connecting. Let's see. Justice Hope, or Juju, as she calls herself on here. Nope. Okay. Antoniqua Hubbard. Hubbard. Nope. Cameron Engel. Willie Lennon. Okay, here's Miss Hubbard checking in now. Admit. I got Miss Hubbard just checking in.
It's going to be pretty brief. This is about 30 minutes.
Cameron Engel.
And I just want to check in with you
on Willie Lennon. And I got you, Miss Hubbard. I just saw you check in, so I got you. Kyla Lofton.
Here.
Skylar McDowell. McDowell. All right. Shadisha McMillan.
Shadeja. Here.
Okay. Lastacia Miller. Miller. All right. Jermaine Mitchum. I saw you somewhere. Let's see. Jermaine Mitchum. I see you. Gotta say something. That would be good. Jermaine. Jermaine. All right. Daniel Moore. I see you. Tatiana Philomar.
Here.
Patrick Price. Patrick Price. Kaylin Red. Kaylin Red.
I'm here.
All right. Parrish Rippey. Parrish Rippey. Joseph Reimer. I saw Reimer on this.
I'm here.
Last name. Okay. Akeem Sirleaf. Akeem Sirleaf. Okay. Ratia Taylor. Nope. Okay. Kerry Watkins.
Here.
Tavis Williams. I see you up here on the board though. Tiana Williams. Tiana Williams. Okay, so that's the roll. All right, we're gonna talk.
I joined late. I'm sorry.
Janera Harrison. I think I might have gotten you because I saw you come in. Let me make sure. Yeah, I got you. I got
Okay,
you.
thank you.
I saw you when
I
you
came
signed
late.
in.
I came in late too, Professor Larry Colbert.
Larry Colbert. I got you.
I
Appreciate
also came in late too.
Jay Downs. Let me see. I got you. I saw you when you came in.
Okay.
Anybody else? All right. So let's have a brief discussion about these first few chapters. Because of course we're kind of making up for last week. So we're gonna briefly talk about chapters 1 through 5. Of course, you guys, I'm assuming you have seen the textbook. It's hard. I got this background on. Let me see if I cut it off. Let me see. All right. Makes it better. Okay. Okay. So you see the book. Now the book is a thin book, so it's kind of a how-to course. It's all about, of course, the book's called Winning Testimony for Law Enforcement Officers. So the book is written from the perspective of law enforcement, but the way I'm teaching it, I'm just teaching it is really about any courtroom communication. All of you aren't going to be in law enforcement, right? Some of you, so I'm not just teaching, and even in this book, it's not just talking about just your communication, how to speak and how to be, how to be heard, how to be believable. But it's also about certain rules of admissibility. So the overall in a trial, one of the most important things that happens or that applies to a trial is the rules of evidence. So there are rules that govern what gets in and what gets out, or what the jury is allowed to hear and be, to have presented to them, and what they're not. So, of course, before I get into it, did everyone see my lectures? Did y'all understand my lectures? Someone answer.
Yes.
Okay.
Yeah.
Of course, we're talking about, the book is so short because it's kind of a quick how-to. So I've had to add content. If you look at your syllabus over the semester, I've also added in cases towards the end. So we're also going to talk about the rules of admissibility of evidence. So you'll know. So the first thing you have to learn, and I know I said this in what's that, the definitely the first chapter and in different chapters. Testimony is evidence. So when a witness gets on the stand and they talk about what happened, they talk about what they saw, that is evidence. As a matter of fact, that is literally even physical evidence can't get in without someone testifying to it. So either way it goes, testimony is important. So if it's a murder trial and you got the bloody knife or what's proposed or what is alleged to be the murder weapon, it doesn't just walk in. Someone has to testify to it. They have to testify to what it is, and then also how it's linked. Hold on. See, Willie Lennon. And whoever Zay is, who's Zay? It's Xavier, probably Xavier Hayes. Hold on one moment, y'all. Sorry about this. Yeah, this format is weird. It's weird doing the Zoom stuff. But gotta get used to it. It's the new normal. So back to what I was saying though. Testimony, witness testimony is evidence. As I said before, even physical evidence, whether it be the murder weapon or a document, it's not going to get in without being testified to. It doesn't just walk into court and someone lays it on the bench and say, here you go, jury, look at this. Someone has to tell us what it was, how it's connected, how they, what research they did, or how they deduced that it was connected to the case, and what their investigation entailed to lead them to come into the conclusion that it was a part of the case. So it's all testimony. So before evidence gets in, it has to be testified to. So one thing we're going to learn over this semester is not just how to testify or effectively communicate in court, but we're also going to learn what type of testimony is and is not admissible. Now, of course, in law school, there's a whole class on just evidence. All you talk about in that class is the admissibility, the admissibility of evidence. We're not going to do all that. We're going to talk about certain important aspects of trial and certain important rules that apply generally. And of course, to most rules, pretty much every rule, there's always some type of exception. So, we're going to learn certain rules. We're not going to learn every exception because this isn't that class. For you guys that are interested in law school, believe me, you will get to it. There's a whole class on evidence. No matter what law school you go to, you're gonna learn evidence. It's gonna be beat into your head. We started off in chapter 1, essentially talking about the anatomy of a trial. So of course, you guys got to see my my lecture on the anatomy of a trial, right? Of course, talked about opening statements, prosecutor's case in chief. The reason they go first is because they have the burden of proof. So, of course, as the prosecutor has to present evidence for there to even be a trial. If the prosecutor has no evidence, that means there is no trial. The case is dismissed, or the person is acquitted. Well, of course, if they don't have any evidence, the case is probably going to be dismissed. It's never even going to make it to a jury. So they have what we call the burden of proof. That means they have the burden of proving guilt, and the burden of proof is in a criminal case is beyond a reasonable doubt. So they have to prove beyond a reasonable doubt that the defendant is in fact guilty. So when we say guilty, and I always tell people, one of my good friends that's a judge now, he used to be in private practice as a defense attorney, named Larry Archie. He used to have a billboard up that was like right at Aggie Stadium, and everybody would laugh at it. He said, just because you did it doesn't mean you're guilty. When we use the word guilty is what we call a legal definition. It's a legal, it defines responsibility in a trial setting. It doesn't necessarily, and what he meant by that is just because you actually took an action doesn't mean that you're going to be held criminally responsible for it. So that's what he meant when he said just because you did it doesn't mean you're guilty. So the burden of proof and proving guilt beyond a reasonable doubt rests upon the prosecution. So the prosecution has to go first. The defendant doesn't have to go at all. The defendant can just listen to their case and sit there and twiddle their thumbs and say nothing, and wait to the end and say, did you hear everything they just said? None of that was true, and it sounds stupid. Please make it make sense. You can't. Find me not guilty. So the defendant has no burden of proof whatsoever. Now, the defendant may decide that they want to put on the defense and offer their own evidence. So the prosecutor has their case in chief where they put on their witnesses and present their evidence. Then, of course, the prosecution rests after they have questioned all their people and entered in all their evidence. Then they rest their case. Then at that point, that's like halftime in the trial. And then, of course, at halftime, you come back after halftime, and it's the defense's turn, and the defense can decide whether or not. Remember, they have the option to not say anything at all, not present any evidence, or they have the option to present evidence and call witnesses. So that's their decision. But once we get back from halftime, then it's the defense's turn. If they decide to put on evidence, then they start the defense case in chief, in which they call their witnesses and present their evidence. And remember, evidence doesn't get in, or physical evidence doesn't get in without being testified to. So you have to line your witnesses up based upon, and this is coming from the attorney standpoint, but we have to line our witnesses up based upon what that witness is going to be introducing, what physical evidence they're going to be bringing in. So that's how it works. Then after the defense's case in chief, sometimes the prosecution is allowed to put on a rebuttal case. Of course, the rebuttal case is usually limited. They're not allowed to open up doors that haven't been opened yet. Of course, they had their opportunity to do so in the initial case in chief, and that was their opportunity. So they don't get to bring up new stuff, but they do get to bring up new stuff as it pertains to stuff that's already been talked about. So let's say if the defense brings up something and they get a chance to rebut and essentially counter what the defense says, or bring in evidence to counter directly what the defense says. So they're allowed to put on a rebuttal case. Of course, the defendant can sometimes get to do a third rebuttal or second rebuttal to that, and sometimes it can go back and forth. But of course, at the end of that back and forth, all cases are closed. And then the prosecution gets to do the open. So in North Carolina, if the defense does not put on any evidence, the defense gets to be the last voice that's heard. If the defense does put on evidence, then the defendant does their closing argument first, and then the prosecutor, they close afterwards. So of course, there's always in a trial when you're trying to convince someone, and when you're trying to persuade a jury to see it your way and do what you want them to do, there's always a strategic edge in being the last voice heard. So,
I found the gummy.
When we get in arguments in real life, what do? We want to have the last word, right? So it's the same thing. You want to be the last one to be heard. So generally, in most cases, the defendant puts on evidence and they present a case. So because of that, normally it's the prosecution that gets to be heard last. So the defense does their closing statement and then the prosecution goes. Then at that point, you have the post-trial motions, and then you have the jury deliberations and the verdict. Now, what I didn't mention at the very beginning, before we even get to opening statements and the beginning of the trial, is jury selection. Now, we're not going to talk about that so much because this is about everything we talk about is pretty much communication during trial. So before we even get to the point where there is a trial, of course, the defendant is arraigned, meaning they ask whether they plead guilty or not guilty. Of course, if they plead guilty, it's a shut case, right? That's it. They're sentenced, right? If they plead not guilty, that means they're saying I didn't do it, so I'm now forcing the prosecutor to prove that I did. If they believe I did, so it's pretty much saying, okay, if you think I did it, prove it. So of course, once that happens, then we have to select a jury. So once that happens, we have to select a jury. Then, of course, that's the process called voir dire. We don't talk about that really in this class, but that's a very important part of the case because we want to get juries. We get to ask questions back and forth to the jurors about how they feel about certain stuff, depending on the type of case, how they feel about law enforcement, go and so on and so on. And then from there, we get the opportunity to impanel a jury based upon those questions. We take some off, we strike them, or we keep them. But at the end, when the dust settles, after the prosecution has exhausted their strikes, we've exhausted our strikes, there's a jury that we both can agree on for the most part. And then we go forward with the case. And that's when the opening statement starts and we present evidence. Then we ask that same group of people at the very end, we do our closing arguments where we ask for what we want. If you're a prosecution attorney, you're asking for the jury to find the defendant guilty. If you are a defense attorney, you're asking the jury to find the defendant not guilty. So that's how it goes. And then, of course, they go in, they deliberate, and then they come out at the end and they render a verdict. And that's the process. So I talked about it more in depth, of course, in the original lecture. But I just want to kind of breeze through it briefly. Chapter 2 is about the prosecution witness. Pretty much talked about being a law enforcement witness, being prepared, being prepared to be cross-examined, because that's another process in the trial. Whatever side is presenting their case and putting their people up to testify, It's a Sixth Amendment right for the opposing party to be able to confront and cross-examine whatever witnesses that the other side puts up and ask questions. So that first, if I'm a prosecutor and I have a witness, let's say I have Kyla Lofton, who's going to be my law enforcement witness. Kyla's on the stand. I ask her questions. I ask her questions to build my case. Once I'm done, I say, hey, the prosecution rests, or the prosecution's done with this witness. Then the judge will say, will there be any cross-examination from the defense? At that point, then the opposing counsel has the opportunity to now cross-examine or ask Kyla Lofton questions about what she testified to, about anything. So they can ask questions that might go to her credibility, whether or not she can be believed, might go to her perception, whether she was in a situation to have actually witnessed what she's saying she saw, whether there's something that might have affected her ability to have perceived it, like was it dark outside? Was there a lot of people out there? Was there something blocking your view or something like that? So they're allowed to ask those questions. So, we talk in later chapters about cross-examination, but that happens with every witness that gets called, whether the defense calls a witness or whether the prosecutor calls a witness in their case. Every witness is subject to be cross-examined. So that's what chapter 2 talks about. Chapter 3 talks about what to do before court, just how to be relaxed, how to prepare. So, of course, as law enforcement, and some of you guys might be in forensics, you're coming to court to talk about highly technical stuff, right? You're going to have to be prepared to come into court and communicate effectively. You may be talking about something that only other forensic scientists know about, but now you have to give the information in a manner that regular people that have been called off the street to now render a verdict can understand. So you have to prepare. You have to know what you're talking about, and you have to come in prepared and be ready. So not only are you going to be prepared to answer the questions that the attorney that's calling you is going to ask you, but you also have to be prepared and know what you're talking about, because you're going to be cross-examined. That means the opposing attorney is now going to hold you to the fire and going to ask you questions. So you need to be prepared to answer those questions as well. Sometimes you won't be prepared, but so you're not going to necessarily know what they're going to ask. But if you know, they can only pretty much ask you information about what you know about. So if you studied and you know what's going on and they ask you questions, you should be prepared to answer the questions, okay? So that's chapter 3. Chapter 4 is about persuasion and how witnesses are used to persuade. So as a witness, it's not your job to argue on the stand. Your job is to kind of just answer questions and tell us what happened. It's the attorney's job, whether it be the prosecution or defense, to build a case. And I think in my lecture, and I say it all the time, we've all eaten cake, right? You have those cakes that have layers where you build, where you put the first layer down and then you put icing over the next layer and you stack until you get a full cake. And then even before you even make the layers, you got to put the ingredients in the cake, mix it in the mixing bowl, and then bake it and all that stuff. Use the right amount of butter. I use that as an analogy to persuasion, and how the litigants or the attorneys in the case are persuading people. So they have a cake to make, and they want to feed this cake to the jury, and they want the jury to like it. They want the jury to devour the cake and eat every bite of it and just love it and say, this is the best cake I ever had. So witnesses are ingredients to that cake. They are layers to the cake. Some witnesses are the cake itself. Some witnesses are icing on the cake. They're extra, and they make it more flavorful. So what type of witness you're going to be is going to be up to the litigant. But as a witness, you're just called there to answer the questions they ask. Know what you're talking about. Tell the truth and answer the questions that they asked, that you're asked. So it's not your job as a witness to argue from the stand. The argument part is all about the it's all about the litigants. When I say litigants, that means the attorneys that are trying the case. It's their job to persuade, and they're using you to build that cake and to tell the story. So part of telling that story and part of being a good ingredient is, for one, being trustworthy, telling the truth. Even if the truth doesn't help the case out and it doesn't help you, it may be something you did in the investigation that wasn't necessarily the right thing to do, or a mistake you made, or something you forgot to do in your investigation that makes you less than perfect. But telling the jury what you did and didn't do and being truthful and just opening up about it makes you believable. So the things that you did do right and the things that do help the case, and sometimes bad things that you do or mistakes you make don't necessarily hurt the case, but they can hurt the case if you fail to talk about it or you lie about a mistake you made. Because, of course, the opposing counsel, the opposing litigant is going to cross-examine you about what you left out or what you didn't say or what you lied about. It's worse to just say, I don't know, or yeah, I made that mistake. I forgot to pull that fingerprint at the crime scene. I didn't do it. It slipped my mind. I didn't do it. I messed up. It's better to say that than to get caught saying, nah, I did perfect, and then end up, oh, but you didn't take the fingerprint, did you? Oh, dang, I didn't. So now it's gonna, even though what you're saying may be the truth, now the jury is now going to focus on the lie you told as opposed to everything else that's more important than that one little lie, that one little mistake you made. Telling the truth is more important than anything. Getting that sun out of my face, my bad. I got a window in front of me. But telling the truth is more important than anything, and having a reputation for telling the truth is more important. And that actually helps with the persuade. It helps the litigants build a persuasive case, because it's hard to persuade a jury once one of the witnesses is now shown to be a liar. So if you're not truthful, that means that the opposing side can say, don't listen to anything they said. They lied about that. What else did they lie about? So you could be coming into court telling the truth. And what you have to realize is juries make decisions not based upon what actually happened. They make decisions based upon what it looks like. So we're building these cake. Both sides are making a cake. And we're making a cake based upon, a lot of times we're trying to make a cake based upon what actually happened. But in a lot of cases, we don't have any evidence that proves exactly what happened. A lot of evidence is sometimes circumstantial. Like, okay, that sometimes there's evidence that just places a person there or puts them in a place where they could have committed a crime, but it doesn't necessarily say that they did commit the crime. Every now and then you have definite evidence like videotape. That's them. That's you with that A&T shirt on, and it ain't that your favorite outfit? Oh yeah, that's you. Sometimes there is evidence like that, that kind of closes the door. But in most cases like that, those cases don't make it to trial. Usually open and shut cases where the evidence is either very good and proves it, or the evidence disproves it. The case doesn't go to trial. So if we're in trial, that means there's some question of fact and everything isn't there, and there's a tug of war to try to get the jury to interpret it a certain way, the way we want them to interpret it. So we have to use testimony of witnesses. That's why the way you communicate is so important, and having a reputation for telling the truth and actually knowing what you're talking about is very important. Actually, I would say telling the truth is way more important. Well, I don't say way more important, but it's more important than actually knowing everything you're talking about. Because if you don't know what you're talking about, you can tell the truth and say, hey, I don't know about that. But I know what I do know. I know what I saw, and I know this. So at least what you do know, you're talking about, the litigant that called you to the stand can now just talk about what you do know. And you've already openly admitted what you don't know. So the other side, you kind of beat them to it. So the other side can't harp on what you don't know because you've already made it an issue. They didn't have to pull it out of you. So chapter 4 was about persuasion. Chapter 5 is about courtroom demeanor. What you have to learn is, because the hallmark of all evidence, even physical evidence, is testimony, you're going to be present. You're going to be present in a certain place and put on the stand, and the jury is taking you for who you are. what outfits you have on, what your attitude is, your body language, all that now comes into play. And even though it's not technically evidence, it is evidence. So the jury, of course, like I said before, they're making decisions not based upon what actually happened, but what it looks like happened based upon the tug of war that's going on between the sides to try to persuade the person to see it a certain way. But when juries walk into courtrooms, juries walk into courtrooms not as robots, but they walk in the courtroom as people. They have certain societal expectations. They are all the societal norms and values, and so how to dress, how to talk. A lot of that stuff comes into play. As a matter of fact, we actually have some discussion boards where we're going to talk about that. Where we're going to talk about, I'm going to give you like an example of a witness in a high-profile case, and we're going to talk about how that witness performed and whether or not that witness should have been believed or should have been treated the way they were treated. So what you have to understand, and that's why a good attorney, before calling you to the stand, is going to, at some point in time, is going to call you into the office or interview you about what you said happened, what you're going to talk about. So as attorneys, if we're preparing our case and we control the witnesses we bring, I hope for certain that as an attorney that's bringing a witness, I would have interviewed and talked to that witness before I called them to the stand. So I know what they're going to talk about and everything. So there would have been a chance to prepare. So at that point in that preparation, I also get to know what type of person this witness is, how they talk, what they need to correct in the way they talk, what their demeanor is. So we can present, I don't want to say the best them, but at least the most believable and the most listened to version of themselves. So not who you are and how you talk, whether it's perfect English, whether it's Ebonics, whether you're good at code switching or not, you are you, and there's nothing wrong with who you are and how you talk. But sometimes it's bad to say this, but sometimes when you are a witness and and your believability is at issue, sometimes you do have to conform to what society wants you to be. And, at least on the stand, you have to talk a certain way. And we're going to talk about that in a discussion board later on. So chapter 5 is about, your demeanor, your body language. If you come in court and you seem disinterested, that means the jury is going to be disinterested in what you have to say. So that means the jury is going to say, well, they don't care, so why should we care about what they have to say? Talk about nervousness versus confidence. There's nothing wrong with being nervous because most of us aren't natural public speakers, right? So there's a difference between being nervous as a public speaker and being nervous because you're not prepared. Like the best way to fight nervousness is to be prepared, because when you're prepared, you're going to be confident, and confidence is the opposite of nervousness. It's how you fight nervousness. So the more you prepare, the less likely you are to be nervous. There's nothing wrong with being a little nervous, but it is something wrong with being so nervous that it affects your ability to speak well. Not even to speak well, but to essentially get your point across when you're testifying. Defensiveness versus openness. Of course, if you're an open book and you're telling the truth from the get-go and like, hey, this is what happened, this is what I saw, I can't say what that person saw, I'm only talking about what I saw from my vantage point. I don't know anything else but what I saw. Being an open book like that lets the jury know this is what he or she knows. And even though it may be limited because they didn't see everything, at least we know what they saw. Being open and saying what you didn't know, as opposed to having to be questioned and cross-examination and having to admit that you don't know everything, that makes you look like a liar. If you get to that stuff first, like I didn't see that. But if you talk like you saw everything, and then the defense attorney has to cross-examine you, and they say, well, you were standing over here, weren't you? And wasn't there a big trash can in the way? Yeah, there was. So you didn't see everything, did you? No, I couldn't see past the trash can. But if you had said that before, without the defense attorney having to pull it out of you, then you wouldn't look like you're holding back or you're lying. So being open and said, when you come in defensive and you have a certain attitude, even against the opposing attorney, it makes the jury say that person, because that person has a bias, and that person is probably lying, or trying to cover themselves and make themselves look good in front of the opposing counsel. So also, let me see, affect evasiveness versus directness. Be direct in your and answering questions, and just generally be polite, but not too polite. Essentially, you don't have to be a kiss up. You can just come in and answer questions and do your job. There's something else I wanted to leave. Hold on. About persuasion and telling the truth. Let me see. Something I felt. Oh yeah. There's nothing wrong. Like, so if you're in law enforcement, or let's say you may be called to help the defense case out. There's nothing wrong with rooting for one side over the other in a trial. There's nothing unethical about that. What is wrong is when that wanting one side to win over the other turns into a bias that now affects your ability to tell the truth. So you may believe the person's guilty, but if you're willing to go up there and lie to do it, then that's when it's a problem. So it's nothing wrong if you're called to be a prosecution witness. You're in law enforcement and you're called to be a prosecution witness. There's nothing wrong with answering. There's nothing wrong with wanting that side to win, but you can't show it in your testimony. In other words, you have to, you can't be so biased that you're willing to tell a lie to skew it for your party's to your party's advantage. So there's nothing unethical about wanting one side to win over the other, but there is something unethical to lie to advance what you want, or that side in winning. So either way it goes, you have to tell the truth whether you want this side to win or not. So I think there's a question about that, whether it's unethical. You might see a question about that, whether it's unethical for you to want one side to win over the other. So those are the first 5 chapters. Of course, you see, our Zooms. I think it probably took me 10 or 11 minutes to call names out and make sure I had everybody accounted for. For this class, our Zooms will never have to be that long. Like, our book is like 100-some pages, right? So it's not a crazy textbook. What I will tell you, and I told you this definitely told you this in my lectures. At the end of every chapter, there are a set of questions that they ask you. They're true and false questions and some multiple choice questions. You at the end of the chapter, you go through and you do those questions. And as a matter of fact, when you flip the book upside down, the book gives you the answers to those questions. So you see the review questions, and then you flip it upside down, and at the top, at the new top or the bottom of the page, it gives you the answers to those questions. So for me as a professor, that's a good means of quizzing you. And so when you have these quizzes, that might be where that might be my question bank. So that's a 100% way to do well. Just do that. Even if you don't read, just do the questions. Honestly, in each chapter has like an overview at the end or a review. I would prefer you read the book. It's not like it's a thick textbook. You could probably, most of you guys are like reading novels, even though this is more boring than novels. This is something you could probably read. I know some people can read fast. They can read 150-something page book in a matter of hours. So you could probably read straight through it, but even if you don't feel like reading straight through it, at least look at the review, at the kind of the chapter review or the review at the end of every chapter, and just do the questions. And that will prepare you for my quizzes, and which would also probably prepare you for my final. So like I said, we're just talking about courtroom communication. Next week, next Thursday, we're going to go over chapters 6 and 7. So in 6 and 7, and chapter 6 and 7 will be available. My lectures will be available tomorrow morning at 7 a.m. So they'll be posted. They'll be up and available. You can click on them and view them. And also, do your reading as well. So my lectures are nothing more than a supplement to the reading. So I can't spoon feed you everything in the lecture. I just talk about major points and things I want to get out. But the book itself is there to be read. So do your reading and study and look at the lectures, and it'll prepare you for our Zoom discussion next week. So I'll see you next week on the 10th. Anyone that has any questions, go ahead and ask. Ask now, forever, or well, hold your peace until the 10th or till you email me. Anybody have any questions? Somebody's chatting me.
I
Yeah.
wanted to make sure that you got me for attendance because I came in a little late.
Who's this? Michaela
Michaela
Cleveland?
Cleveland. Yeah.
I want to say I did when I saw you. Yeah, I got you. I got Willie Lennon. Willie checked in late too. Let me see. Yeah, I got, yeah. So I think
Okay.
I got everybody. I got you. Yeah, I got Willie Lennon as well. So you guys be good. Enjoy this session. So just be prepared for chapter 6 and 7 next week.
I have a
Take care.
question real
Oh,
quick.
go ahead. Go ahead, Tatiana.
So, you usually post the videos on YouTube, right? On your channel. I only found lectures for chapters 4 and 5. I didn't see 1 through 3.
Well, okay. When you go to learning units, so you have and Blackboard, when you click learning units, I actually have a link to every chapter lecture. So it's harder to find if you just go on YouTube and search it than it is if you just click on our cards. I've already provided the link. So if you go through Blackboard on the left-hand side of the page, it'll say learning units.
Yeah.
Click on your learning units, and I've already. Well, of course, as a teacher, I know I see everything I've done because I've already timed it out to be released at a certain time. I think you guys are limited in what you guys can see. You only see what I make available to you. So right now, when you go up there, you'll see like the lectures for chapters 1, 2, and 3, and then you'll see chapters 4 and 5. So instead of going straight through YouTube, go through Blackboard and click the link. So instead of you having to search for it on YouTube, you can you can click the link and go directly to it without having to search for it.
All right, cool. I think I found it right now too.
Mm-hmm.
All right, thank you.
All right. Glad I could be of assistance. Any more questions?
Our first quiz, is it going to be multiple choice or is it?
It's 100% multiple choice.
Okay.
And it'll be up. So we have a Zoom meeting next week on the 10th. The quiz will be up it'll come up at 7 a.m. on that Friday, the 11th, and it'll be up through Monday, the 14th.
And that's the final day you can take it.
Yeah, so you have between Friday at 7 a.m. and Monday at 11:59 p.m. So that gives you a few days to take it. Now, honestly, I already told you where I get the questions from, so so as soon as you see the quiz is up, why not jump on it and just get your 10 points?
Okay.
So that's the best way to do it. And I'm talking to everybody, not just you. Why not jump on it? Don't procrastinate. We're doing online classes, so the more you procrastinate, the more you build yourself in a hole. So if it's an easy way to just go and get your points, take the easy quiz. It's 10 questions. Just jump on in and do it. All right. So any more questions?
No, thank you.
All right, y'all be good. Take care.
Bye-bye.
Bye, thanks.